He will now discuss hardware and liability issues. Champ.
Thank you, Ann. I was asked to whether I had any exhibits or any demonstrative evidence, slides and so forth. I said no, because I really couldn't think of any I wanted to have in discussing liability for computer malfunctions, either in the hardware or software area. I did have a good piece of demonstrative evidence. This is a complaint. It was filed in the Circuit Court of Cook County in January of this year, and until last night I didn't know how much it weighed, and I thought, I can imagine the clerk's office over there when they saw this, they would have no idea what to do with it. I weighed it, and it weighs 4 pounds. And I don't know whether it sets a record for the size of complaints filed in the Circuit Court of Cook County. And furthermore, since I'm working on the defense side, I'm going to take the position that's probably subject to a motion to dismiss. And hopefully, since it weighs so much, they will probably want to grant the motion to dismiss. What I'd like to do is I'd like to cover various theories of liability that have been raised, and I think these theories are important to you whether you're involved in litigation or whether you're involved in counseling or drafting, because I think once you have a grasp of the various theories of liability, you can use them regardless of what your practice is. And then hopefully, if we have enough time at the end of the talk, I'll go back and discuss the theories that have been raised in this complaint. It's a 7-count complaint, and the complaint itself is fairly complex, but in state court, unlike federal court, there's a rule that if you're relying on documents, you really should incorporate them into your complaint. In federal court, you can pretty much get away with notice pleading, and you can save the documents for later. So the bulk of the complaint is really, this is the complaint itself, 7 counts, and then the rest of it is devoted to the documents which the plaintiff believes are relevant to the causes of action that it has alleged. Again, we dispute a lot of the relevance of those documents, but nevertheless it should make an interesting exhibit. Now, on the theories of liability, despite the fact that I'm speaking at a computer law seminar and we're talking about computer law for the 90s, there really isn't any body of computer law that you look to tell you if you're a purchaser of a computer that malfunctions, whether you have a claim, or if you're a vendor of hardware or software or of a system in general, whether you have defenses. There's no such thing as computer law itself, but because of the number of computer cases that there have been over the years, there is what I would call a pattern of issues that arise in these types of cases. And I think the best I can do today in the time that I have allotted is to discuss with you and raise with you what those issues are. I don't think we can resolve them because there are really some of these issues there's no black and white answer. So I think the goal is to be able to identify the issues, to be able to know to what body of law you want to look for in assessing either whether you have a claim or whether you have a defense to that claim. And then as you approach specific problems, then you can do a lot more research. And believe me, there are a lot of sources out there. I went to the John Marshall Library last night and looked through the card index under computer law, and there were 2 or 3 volumes on computer litigation theories, which is essentially my talk today, and one of them was 1,000 and some pages, and one of them was 800 and some pages, and that does show the complexity of the issues. And then there are many, many other articles and treatises on just devoted to one single issue of what I would call computer litigation law. So there's plenty of material out there, and what I'd like to do is identify the issues, and then when you get specific issues, I would suggest you go to the treatises and the law journals and look for some of these articles, and chances are somebody has written an article on that particular issue. The body of law that we need to look at is obviously, as you all know, the UCC, and that there is some variance in that from state to state. We also need to look at common law principles in case the UCC does not apply. And then an area of law that we also need to look at is what I would call other statutory law. Now, I view UCC as statutory law, then you have common law, contract, and tort, and then there are a variety of other statutes that may be relevant, and several of them have been alleged in this complaint that you should be familiar with. They may or may not be relevant to a complaint for a computer malfunction. A typical factual setting that you encounter is two parties, although listening to Mr. Gordon's talk yesterday, and he had all the vertical relationships and the horizontal relationships, today you may encounter many more than just two parties. But I don't think that changes any of these principles I'm discussing. I think the principles apply and you should become familiar with them. They're more difficult to analyze if you have multiple parties. And one of the things Mr. Gordon said yesterday is what you really want to look for is you want to look for somebody who will bear overall responsibility. And I think that's true, and I think that's a good word of advice, because as you'll see when you start going through these theories, the more parties you have, the more difficult they are to apply. But the typical setting involves two commercial enterprises, one of which is a buyer of computer system, hardware, software, or both, and maybe also a buyer of services. Often there's an extensive period of negotiations, lots of technical literature. Again, attached to this complaint is a lot of technical literature, which may or may not be part of the contract. And there generally is a standard contract. And when I say a standard contract, it's often starts out as a printed form contract, and it may have been the vendor's contract, and it may have provisions in it which are you see in many contracts and which are non-negotiable. There may be disclaimers of implied warranty. There should be limitations on consequential damages and limitations on various remedies. But that's the typical setting. And then the next fact is there is a deficiency in the performance of the system that the user purchases. The issue then becomes for the user what the user does to remedy the deficiency. Often the user will look to the contract, and there may be provisions within the contract that tell how to remedy the deficiency, but more often than not, there are a lot of limitations in the contract, so what the user will have to do is attempt to come up with what I would call innovative legal theories to try to resolve its claim. And whether or not the claim goes to litigation, you need a handle on these legal theories, at least to discuss the possibility of getting further relief, particularly if the vendor has disclaimed rights and responsibilities. Now, one way to analyze the approaches on these various theories, and I find this a fairly easy way to do it, you have approaches under contract law, you have approaches under tort law, and you have the statutory approaches. And I've outlined the statutory approaches in the outline, and the outline is intended to give you a brief overview, but they involve RICO, state consumer fraud acts. Sometimes those are known as little FTC acts or deceptive practice acts. Illinois has one. The Magnuson-Moss Warranty Act, that's a federal statute that may or may not give you some relief. The Lanham Act, it's primarily an intellectual property, a trademark or unfair competition statute that may or may not give you some basis for a claim for a problem with the quality of a product you purchase. And then there are a few states who are talking about passing laws that single out the computer industry. I say there's no special body of computer law, but in a few instances there are. I believe New York is one of the states, and there's another state or two. They're trying to pass legislation saying that it's unlawful for a seller of computer equipment or software to disclaim warranties. And what these are consumer protection statutes, and the theory being that if you purchase, say, off-the-shelf software, it's likely to be sold as is, and you really don't get anything at all in the way of a warranty. And I'm sure the computer industry isn't the only industry where there are warranty disclaimers. but I think there have been a lot of complaints about getting defective products and having no remedy. So some states are starting to consider these consumer protection laws. So if the type of product you're talking about is a consumer product, you might want to do some research and see if the state that you're interested in has that type of a law. Now, getting back to the three-pronged approach, let's look first at contract law. In my view, is the approach that you ought to be most familiar with. The first issue under the contract, the body of contract law, is what contract law applies, and that's a very important issue and often a difficult issue to resolve, and it boils down to whether you look at common law principles of contract or whether you look at the UCC. Now, we've already had a little bit of insight on the UCC as it applies or may in the future apply to lease transactions, but the sections you need to look at are, in Illinois, the UCC is Chapter 26. You should look at Section 2102, and that talks about the UCC applying to transactions and goods. And then you look at 2105, and that defines goods as all things which are movable at the time of identification of the contract. Well, that could cover a lot of things. That could cover software that's already developed, regardless of the form that the software is in. It would certainly cover computer hardware. But the types of issues you get here, number one, if you're looking at a sale versus a lease transaction, the question is, does the UCC apply? Now, obviously, it applies to a sale of goods transaction, but there's a question as to whether it applies to the lease of goods. Now, several courts have taken the position that a lease of goods, it really is tantamount to a sale of goods, and even though it is a lease, if it's a tangible product, the UCC can't apply. And often you will see in lease documents disclaimers of implied warranties and other provisions that wouldn't be in there unless the drafter thought that the UCC applied. Another interesting issue is whether you have the sale of goods or the sale of services. Now, sometimes you'll enter contracts where there's one separate contract for the sale of hardware, a separate license agreement for the software, a separate maintenance agreement for the performance of maintenance services, and so on. In those cases, it's fairly clear that you have rights under this contract, you have rights under that contract, and the UCC may apply to this, and it doesn't apply to, say, for example, the maintenance agreement, because that's the performance of services. Other times, the agreements are all put together in a single agreement, and that raises an issue as to whether the UCC applies to that agreement. And the courts have applied various tests. I'll just throw out some of the language from the cases. One case says the issue is whether the seller does or whether the seller gives. And that's a very simplified test, but if the seller gives, I can imagine going into court and arguing that, but you might use it by analogy. If the seller gives, then it is a tangible product, and the UCC would apply. Another test that a court has expressed is what is the essence of the agreement? Is the essence of the agreement, is it a sale of goods or is it the performance of services? Are the services incidental to the contract? Some courts have used that approach. Courts have used the dominant thrust test, and when they get into the dominant thrust test, they're trying to determine whether the dominant thrust is a sale or the performance of services, and often they will look at the cost of the products involved. Are you paying more for the hardware and a much less amount for the maintenance services or other services that will be performed later? Again, there are many, many cases on this point, and I don't purport to have any definite answers for you. What you should realize is that is always a problem. And if you conclude that the UCC applies, which I'm going to assume for purposes of the rest of this talk because I think that's likely in many instances, then what you should do is begin your analysis of rights and remedies starting at Section 2301 of the UCC, and that talks about the obligations of the parties. If the UCC doesn't apply, then your research efforts will be a little more difficult. I happen to enjoy it when the UCC does apply because you've got everything, even though there are many, many, many cases, you've got really a compact body of law that is relatively easy to follow and to understand, although you may have decisions on both sides of the issue. Now, assuming the UCC applies, a provision that you should be interested in right away is 2313. And that provision is entitled Express Warranties by Affirmation, Promise, Description, and Sample. And really what that provision is that's the provision that if you're having a breach of contract claim or considering a breach of contract claim, it's really this provision that you're talking about. Now, most of the contracts, most of the times you'll end up with written contracts, but that doesn't mean that you couldn't have an oral express warranty. Now, Section 213 says that express warranties are created as follows. One, any affirmation of fact or promise. Well, that could be anything in the contract that is an affirmation of fact about the goods or a promise about the goods. Now, the affirmation or promise must relate to the goods, and it must become a part of the basis of the bargain. And if it does, it creates an express warranty. Now, becoming part of the basis of the bargain is important because you could have oral affirmations of fact, or you could have oral promises about the products, but if you have a written contract, the issue is, do those oral promises, have they become part of the basis of the bargain when the parties signed a contract over here and the promises were made over here? Other sections of the code that bear on that issue are 2-202, and that's the parole evidence rule. That's an issue you will face if you're trying to rely on oral statements or representations, and you're trying to say that those constitute express warranties. Well, you can say, well, they related to the goods, clearly, but they were oral. So if they're oral, you're faced with a parole evidence problem, and if the parties intended a writing to govern, then I think those oral promises wouldn't be a part of the contract. Now, you could have written promises in letters and correspondence and specifications and RFPs and so forth that aren't part of the contract, that aren't in the contract itself. And then the issue is, are those express warranties, and are those express warranties actionable? Now, in the oral area, we have the parole evidence rule to worry about. In the written area, you have what you generally have in contracts, what is known as an integration or a merger provision. And those provisions take various forms, but basically they say that everything that's part of the bargain is in this document, and all prior representations and understandings and discussions and so forth are excluded and are not part of this contract. So that's the analogy to the parole evidence rule when you're talking about writings, is the integration provision. And in almost every contract I have looked at, there is an integration provision, so you do have that issue. And again, it gets back to whether the promise becomes a part of the basis of the bargain. And if it's not put in the contract, and if you have an integration clause in the contract, you have a very good argument that that's not part of the basis of the bargain. Now, I want to refer you, there are hundreds and hundreds of cases, and we just obviously can't get into them, but I do want to refer to one case. This was a case that Ann referred to me some time back. It's a very interesting case to read, and kind of shows you the arguments on both sides of this area as to what constitutes an express warranty. And the case is Sierra Diesel Injection Service versus Burroughs Corporation. And it's the citation, it's 874 Fed 2nd, 653, and it's a 1989 Ninth Circuit decision. And this was the sale of a computer system, and Burroughs had a written contract, and the written contract had an integration provision in it, and the sale was to an individual or a very small business person who was not sophisticated. And the court found, the court in effect disregarded the integration provision in the contract, and it found that statements written in letters that preceded the contract really did form a part of the contract. And in ignoring the integration provision, the court said, the Court of Appeals said the trial court found that the plaintiff was not a sophisticated businessman, that he had little knowledge of computers or of contract terms, and that he fully expected that the representations made to him by the Burroughs representative would be a part of the contract. Now, again, keep in mind that the court emphasized those factors even though the contract itself said that everything that's not part of the contract you can't rely on or you have no rights under. Burroughs argued that as a matter of law the merger clause should determine that the contract was integrated, and the court said that the court went on to emphasize that where the contract was a pre-printed form drawn by a sophisticated seller and presented to a buyer without any real negotiation, then the integration issue is one of fact. And as you can tell here, the court sided with the plaintiff. And basically, they concluded that the plaintiff was not sophisticated, and for that reason, since it was a printed form contract, the integration clause wouldn't apply. Now, that would be a very, very minority view. And again, the factual setting that I gave you usually involves often two sophisticated business entities, a long period of negotiation, discussions about the contract, lawyers reviewing the contract, and so forth. But you ought to be aware of that case because it does give you an argument, and it is an issue to consider. Now, the safest course, if you're representing the buyer, is to make sure you incorporate everything you want to into the contract, obviously if there is an integration clause, so that you can claim that these are express warranties. So what you want to do is try to get your RFP incorporated into the contract and so on, and obviously the seller will say, no, we don't want all that in there. But what you want to do is say you want this as a part of the basis of the bargain so that you don't have any problems with the integration provision. Now, the next area of contract law, and we're still under the UCC, I've discussed express warranties or implied warranties. And I won't spend a lot of time on implied warranties for two reasons. I think you're probably all familiar with the implied warranty of merchantability and fitness for purpose, and moreover, they're often disclaimed. So a lot of times they really aren't relevant in the cases. Section 2314 covers implied warranty of merchantability, and 2315 is implied warranty of fitness. Now, this is an important reason to, if you're trying to advance a claim, to say that the UCC applies so you do get the benefit of these implied warranties, because if you're left to your common law remedies, then these warranties wouldn't be implied. Now, what the code giveth, the seller can taketh. So I will refer you to 2316, and that UCC provision is the exclusion or modification of warranties. Now, and I'm sure you've all read cases here. There are two aspects to this that are interesting. Number one, if you have an express warranty, it is difficult to disclaim an express warranty. And if you think about that, that makes a lot of sense. Why should somebody be able to say in paragraph A what they take away in paragraph B? That creates confusion and so forth. So what the code says about express warranty exclusion is that words or conduct relevant to the creation of an express warranty and words or conduct tending to negate or limit the express warranty shall be construed wherever reasonable as consistent with each other. So you can see it's important to get your provisions into the contract, then it's more difficult for the seller to negate the express warranty. A couple of cases, again, look at the Sierra Diesel case. In that case, the Sierra Diesel case took the position just flat out that if you have an express warranty, it can't be negated. I think other courts might take a more modified approach and look to the language and see really was there an intent. Maybe this wasn't an express warranty. Was there an intent to negate it? Now, the issue with implied warranties, I'm sure you all know, and as drafters, you've all taken great pains to capitalize all your warranty disclaimers, to mention warranty of merchantability, to underline them, to redline them, to do everything to make them conspicuous. And that's the issue in disclaiming an implied warranty of merchantability or fitness. Have you mentioned merchantability, and is your disclaimer conspicuous? I'll again refer you to the Sierra Diesel case. And here are the interesting facts in the Sierra Diesel case. In bold type, the contract said, except as specifically provided herein, there are no other warranties, express or implied, including but not limited to any implied warranty of merchantability and fitness. Now that is in bold type, I mean in all capital letters. That's in the contract. However, there was one slight difficulty. It was on the back side of what I gathered was a two-page agreement. On the front side of the two-page agreement, the language said the terms and conditions, including the warranty and limitation of liability on the reverse side, are a part of this agreement. Now, you can guess what the court held. Obviously, the court wanted to hold for the plaintiff. The court held that that disclaimer was not conspicuous. Again, I think that would be a minority view, and I don't think you have to stay awake at nights worrying about whether your disclaimers, if you're the drafter, worrying whether they're conspicuous or not. But the language in that case that you may want to look at says whether a disclaimer is conspicuous is not simply a matter of measuring the type size or looking at the placement of the disclaimer within a contract. Now, those are the rules that we're all used to. Look at the type size, look where it's located, and so forth. A reviewing court must ascertain that a reasonable person in the buyer's position would not have been surprised to find the warranty disclaimer in the contract. And they went on to say, again, that the buyer wasn't sophisticated. They also noted that the buyer said he didn't read the back side of the contract. Again, I think it's a harsh result, but you ought to look at that case. That'll be fairly educational. Now, thus far we've covered express warranties, we've covered implied warranties, and we've covered disclaimers of both of them. So you have to go through all that thought process to find out exactly where your claims lie if you're trying to advance a claim, or how to defend your claims if you're trying to defend a case. One other code area in the contract arena is also found in 2316, and that's called limitation. It deals with limitations on remedies. And these are very common in hardware and software contracts. And this is subsection 4 of 2316. It says remedies for breach of warranty, either implied warranty or express warranty, can be limited in accordance with the provisions of this article on liquidation or limitations of damages and on contractual modifications of remedies. So you need to look two more places to see exactly what you can do. If you look at section 2718, that's called liquidation or limitation of damages. And that allows, that's 2718, and then 2719 is called contractual modification or limitation of remedy. Now, I'm confused when I read these provisions because 2718 really deals with liquidated damages and says you can have liquidated damage provisions, but it's entitled limitation of damages. You go to 219, and that's entitled limitation of remedy, and this is a section that deals with limitations on damages. So it seems to me this ought to be in here. Do you have any legislative history on that? Or am I misreading? Probably am. But in any event, look at these two sections, and 219 says that the agreement may provide for remedies in addition to the code remedies, and the agreement may also limit or alter the measure of damages recoverable as by limiting the buyer's remedies to return of the goods and repayment of the price, or to repair and replacement of non-conforming goods or parts. That is a standard limitation. Now, if that repair or replacement you often see in this connection with sale of tangible goods. Now, the code goes on to say resort to that remedy is optional unless the remedy is expressly agreed to be exclusive, in which case it's a sole remedy. And that's why you see the language that the sole and exclusive remedy for breach of this agreement or breach of warranty shall be limited to repair or replacement of the goods. But in any event, you should look at those two provisions, 718 and 719. Now, there are a few other remedy limitations. One is found in section 2725, and that's an important limitation that sometimes is overlooked. It's a statute of limitations limitation. And this provision says an action for breach of any contract for sale must be commenced within 4 years. By the original agreement, the parties may reduce the period of limitations to not less than 1 year. I've seen some agreements that use 6 months or 3 months or 90 days and so forth, but be careful of this provision. Maybe it varies from state to state, but I think to be on the safe side, if you do reduce the period of limitations, I would reduce it to not less than a year. Final issues in the contract area. If you represent a buyer and you have a malfunctioning computer and you're worried because all of these disclaimers have been put in the agreement and you see that you have absolutely no rights whatsoever, you should look at Section 2302. That section deals with unconscionability, and in some cases, provisions have been struck down as unconscionable, and that gets back to a little bit to the Sierra Diesel type situation. If the contract is ambiguous, which I hate to say it, but many of the contracts we draft are, the contract might be construed against the drafter. Limitations in one contract may not apply if there's a separate agreement. So if you've got separate agreements, you may have that argument. And then finally, there's the failure of essential purpose doctrine, and that is set forth in Section 2719 of the Code. And basically what that says is if the seller, the vendor, tries to limit its remedies, for example, to repair or replacement, and then later the seller really is never able to repair and doesn't replace the product, doesn't live up to that remedy, then that limited remedy fails of its essential purpose, and then everything is out the window, and then you go back to the UCC remedies. And that raises a whole host of issues, because what UCC remedies do you go back to? For example, if a seller has said, I'll limit the remedy here to repair or replacement, and then for whatever reason the seller doesn't repair the defective product, and then the seller also in the agreement has a clause saying in no event can the buyer or the user recover consequential damages, does that get thrown out too? In other words, if the seller fails to repair as agreed to, then can the seller still say my consequential damage limitation is valid? And there is a real dispute there, and that's always an issue, and I suggest you look at the cases on that issue. Now, that pretty much sums up the theories of liability under the UCC. I won't get into common law theories because those are just common law breach of contract principles. You should be aware that remedies are set forth in 2701, and that covers seller's remedies, buyer's remedies, such as rejection, revocation of acceptance, and various damage theories and remedies. And again, you almost have to read through the code each time you're interested in these issues, because they are fairly complicated, but again, fairly straightforward. Okay, to summarize the contract issues, what body of law applies, UCC or common law? If UCC applies, are we talking about express warranties? Are we talking about implied warranties? If we're talking about one or the other, are there any disclaimers? Express warranties are difficult to disclaim. Implied warranties are easier to disclaim. It must be conspicuous and so forth. Once we get past those hurdles, if we have any rights left, what are the remedies? Are there any disclaimers on the remedies? You have to go through the steps that we went through to see the various disclaimers. And then if there are so many disclaimers that you really have no remedy at all, can you argue unconscionability, can you argue ambiguity, and so forth? When all fails, now we get to the interesting part. You may have to, if you're trying to advance a claim, I didn't mean to imply that the UCC is not interesting at all, because it really is, but if all fails and you feel you have no contractual remedies, then you have to look at your tort remedies. And the tort remedies that I'll cover, they're set forth in the outline, and I'll cover them very briefly, are negligence in design or manufacture, obviously a difficult burden if you're a plaintiff and you're trying to show that the vendor or software developer was negligent. Within the negligence area, there's ordinary negligence, and at least in this complaint and in other complaints, there are theories of professional malpractice. And the argument is essentially that somebody in the computer business is in a profession and they ought to be held to a higher standard of care. But basically, it's a negligence argument, and that'll be important, as you'll see in just a few minutes. Strict liability, that's a possibility. That's a defective product, usually considered unreasonably dangerous. It's nice to have that type of an argument, because you can't disclaim, basically you can't have disclaimers of strict liability. And then finally, there's the area of misrepresentation, and there are various degrees of misrepresentation, and it's not unlike Section 2316 that I talked to you about express warranties. You can actually go back to the UCC and see what you need to show for misrepresentation. There are various degrees of misrepresentation. There can be an innocent misrepresentation, a negligent misrepresentation, and fraud. And the main difference between express warranties as set forth in the UCC and fraud is that the seller knew that the promise was false and had the intent to deceive. Under the UCC, the express warranty, there's no requirement of scienter. Now, the main issue in the tort area transcends computer law entirely, and that issue is whether parties that suffer only economic loss ought to be able to sue in tort when they have sat down and under the UCC they have negotiated their rights, they've put in their disclaimers, they've incorporated their RFPs, and they've spent a year and lots of legal fees and so forth, and they've got a nice agreement and they want to live by that agreement and carry on their work and sleep at night and so forth. Should they be able, should a buyer who's faced with a defective product be able to sue in tort when that very buyer said, no, I agree to all these limitations, I agree to limit my remedy and so forth? And the law today is getting to the point where the answer is no, you really shouldn't be able to sue in tort. And the cases you should look for in Illinois, and there are many other jurisdictions that follow this doctrine, it's called the economic loss doctrine. The case in Illinois, the key case is Mormon versus National Tank Company. And that's 91 Illinois 2nd 69, and it's a 1982 case. And basically it says it leaves the parties to their commercial rights if the loss that they're talking about is purely an economic loss. Now, it doesn't change the law if you're talking about a catastrophe, an explosion, property damage, personal injury, and so forth. But what I'm talking about today, and that most of you will be interested in, are really economic loss cases. I didn't get the benefit of my bargain. So under Mormon, it really says you can't sue in tort anymore. Now, it's taken Mormon a while to become popular, and there are still many cases over in the Circuit Court of Cook County interpreting the full scope of the Mormon doctrine. Now, for those of you that may have claims or represent purchasers and think you're really out of luck because the contract has taken everything away from me, I have absolutely no rights, I can't go into court now and sue under any tort theory, I have absolutely no rights, you ought to know that there are some exceptions to Mormon. And what you should know those exceptions. First, the one I've already mentioned is personal injury, fraud, misrepresentation, and intentional tort is the biggest exception to Mormon, and that's the exception that will be most important to this area. And again, it gets back to, was there a promise, was there a representation, was it made knowingly, was it false, and was it made with the intent to deceive? And if so, you can prove that, you can prove fraud, and then even though it's a tort theory, the Mormon doctrine won't throw you out of court. Now, one sort of nebulous theory that's an exception to Mormon is called negligent misrepresentation. That's been pleaded in this complaint that I referred to. And negligent misrepresentation is a misrepresentation that's not made knowingly false, maybe with a careless disregard to determine whether my computer would do this or do that even though I said it. But the case you ought to look at there, it's, and I think I've got it listed in my notes, is Black Jackson versus IBM. And that case puts some severe constraints on a negligent misrepresentation theory. And basically, it says that theory applies only if the defendant is in the business of supplying information for the guidance of others in their business transactions. And the court held that IBM was a seller of hardware and software, really didn't fit within this category. So what you need to look for is if you have a situation where you've got a consultant and you rely on the consultant, maybe you could state a negligent misrepresentation claim against the consultant. Now the reason you'd want to do that is because you can state a claim for negligent misrepresentation. You don't have to show intentional fraud. And the final area, which until very recently was an exception to Mormon, was professional malpractice. And there's an allegation in this complaint about professional breach of duty, and maybe that's the reason it's in there. But the First District Court, Illinois Appellate Court in Tolona Pizza Products Corporation versus Davy McKee, and Davy McKee was an engineering firm, said that malpractice is no longer an exception to Mormon. Now, I unfortunately was on the wrong side of that case because we were saying that malpractice still was an exception to Mormon. That case was not appealed. The case is still going on because there are breach of contract claims and other claims in the case, and that issue can be appealed later to the Supreme Court. But there is a case in the Illinois Supreme Court. It's called 2316 Lincoln Park West, and it's been argued. It hasn't been decided yet, and the issue there is a malpractice claim an exception to the Mormon doctrine, which says you can't sue in tort for economic loss. Now, elements of fraud, I won't spend a lot of time on. I think you all know, and again, they're similar to the express warranty provisions in 2316 or 2313 of the code. The protection that you get for fraud if you're representing a seller is the fraud does have to be shown by clear and convincing evidence. You can't just throw out some theories and hope that they stick. The pleading has to be pleaded, fraud has to be pleaded with specificity, and this complaint had been previously dismissed in state court because it hadn't been pled with specificity, so I assume now that they have, or at least they think they have. You have to base the fraud allegations on a statement of fact rather than opinion. So if you represent a computer company and you've got a vigorous salesman and it's near the end of the quarter and all sorts of puffing and opinions go on, you may have an argument that really wasn't fraud and so forth. There has to be scienter and there has to be reliance. Now, a fraud claim can be a very potent claim for a buyer because you can get punitive damages and so on, and it gets you around all the contract limitations because you say, I'm claiming fraud in the inducement that induced me to enter into the contract, but for the misrepresentation I wouldn't have entered in the contract, and therefore all these disclaimers and limitations fail. So the fraud is a very potent remedy. The UCC contains a provision entitled Remedies for Fraud, and that's section 2-721, and it just says that neither rescission nor a claim for rescission of the contract shall bar or be consistent with a claim for damages or any other remedy. And that's because in fraud, your remedy is often rescission, and the UCC says that that doesn't bar you from pursuing your other remedies. Now, to give you a short summary of the tort area, you're out of luck on most tort theories. You're out of luck on negligence. You may have negligent misrepresentation. Fraud or actual fraud in the inducement would be the best tort theory that remains. Now, the final area I'd like to cover are statutory claims, and I'll just take a couple of minutes to cover those. There is the State Consumer Fraud Act, and that's Illinois Revised Statutes 121.5, Section 262, and what that prohibits is deception, fraud, false promises, and so on. And here's the key. And the use of any practice which is described in the Uniform Deceptive Trade Practices Act. Now, this is all part of the same statute, but you have to go then from Section 262 to 312. And 312 is the Uniform Deceptive Trade Practices Act, and that says, among other things, it gives a whole laundry list of practices that are considered deceptive practices, and one of them is making a representation that goods or services are of a particular standard, quality, or grade. And that's a very broad statement right there, and there have been several instances, and there's a consumer fraud allegation in this complaint, and the potency there is that the Mormon doctrine doesn't bar it, even though it might be in the nature of a tort claim. You can get punitive damages, you can get actual damages, and you can also recover, if the court sees fit, you can recover attorney's fees. So that's a fairly potent weapon. The big issue in that area is this, however. There may be a requirement in a Consumer Fraud Act case, and it's often referred to as a little FTC Act, there may be a requirement that the plaintiff show public injury. And this almost is analogous to the RICO area, and I've mentioned RICO in the outline, and this case started out as a RICO case. We got the RICO count dismissed in federal court, and all of the state counts then fell by the wayside, and we got the RICO count dismissed on the theory that there was no pattern. We didn't think there was any racketeering activity in the sale of hardware and software, but there was no pattern of racketeering activity. But back to the Consumer Fraud Act, there are two cases that I will refer you to. One is Beaton versus Beaton versus Joslin Manufacturing Company, 512 Northeast 2nd, 1286, and Maduff, M-A-D-U-F versus Life Insurance Company of Virginia, and that's 657 F Sup 437. In particular, the federal courts here in this district are of the view that you have to show public injury. You can't just come into court with a private dispute between two contracting parties and say that it states a Consumer Fraud Act claim. And there are several unreported decisions in the Northern District that involve the sale of computer hardware or software where the courts have thrown out the consumer fraud claims. But the advantage, if you can state a consumer fraud claim, is you probably don't have to show intent or scienter. You probably have to show that you're entitled to recover not by clear and convincing evidence, but only by a preponderance of the evidence. Opinions may be actionable, and you may be able to recover attorney's fees. So it's a powerful weapon for the right type of case. RICO, we could spend days on. I'm not a fan of RICO. I don't think it really holds any place in this particular area. I'm sure somebody can refer to some cases where maybe there was a legitimate RICO claim. The Magnuson-Moss Consumer Product Warranty Act is 15 U.S.C. 2301. Basically what that does is regulate the content of warranties, and where that may be relevant is if you have a consumer product and there is an attempt to grant an express warranty, then the Magnuson-Moss Act says you can't disclaim implied warranties. So again, it's a consumer protection type statute, so if you're talking about the purchase of off-the-shelf software or some other more of a consumer product and a non-negotiated transaction, you might want to look at that. And you might want to also look at the Lanham Act, although again I don't hold a lot of weight in these statutory areas. In short, these theories, contract, tort, and statute, you should go through this analysis each time you're considering a claim or when you're drafting documents, and I think these theories are equally valid to the complex situation that Mr. Gordon drew yesterday. Again, much harder to analyze, but they do hold validity. It'll take you more time to go through them, but once you get this framework of analysis down pat, I think it applies to any case, and it applies to cases that go beyond the computer area too. Thank you.